material to cover, so I'll jump right in. I do kind of consider that my marijuana in the workplace course is a precursor to the drug policy writing, but today we are only doing the drug policy writing workshop for you. So if at any point you feel like, I might need to know a little bit more about what she's referring to, do go and watch that recording of the impact of marijuana in the workplace because it really is quite different than you would expect if you haven't already seen it. So, what we'll be talking about in light of usually springboarding off of that information is the value of a policy, understanding. Now, that says Nevada law. It's actually Illinois law. I apologize. I've been through this, 20 times now. Got that typo. Reviewing best practices for policy, earmarks of what is a good policy, and then the content, which is actually the largest portion. I do want you to understand I am not an attorney. But the information that I am providing has been vetted out by attorneys. I've presented with attorneys on many occasions. I've had attorneys take my course, and they all say, wow, this is great information and helps me to prepare to help my clients write workplace policies. I understand that not all attorneys are familiar with drug testing law. So many times you go to an attorney and say, can you just put this in my policy? And they add a boilerplate, some language that their office came up with. And it can really be quite wrong when it comes to how drug and alcohol testing works. So it's a good idea to have both sides, the expertise in the drug and alcohol testing arena, and then put eyes on it by an attorney. But if there's anything that they want to change dramatically, then we need to have a conversation. However, make sure that you understand this isn't legal advice of any kind, it's policy advice. All right, some things to know before you dive in. Now, most of you're typically either coming from one of two places. You either are like a new business and don't have a policy. Maybe you've been around for a little while and you've never put a workplace drug and alcohol policy into effect, and you're going, oh, I need this now. Or you've been around for a while, there's a policy somewhere, you know it exists, you've never really actually maybe used it, or the laws are changing, and whatever's precipitating it, it's time to update. And so either way, we'll help you out today. And know that once you complete the course, you will get two sample policies. And I will use both of these policies in our course today. One is a short form and one is a long form. And so you'll get copies of those to use and compare to whatever it is you have or don't have. Okay. And that will help you tremendously. Now, we are in a shift culturally where companies are being encouraged to define who in your employ is safety sensitive and who is not based upon their duties. Now, there is this big tendency in the workplace to kind of think as safety sensitive through the lens of United States Department of Transportation only. And that's incorrect. While that is a great definition of safety sensitive and it's valuable to us, safety sensitive in DOT really is who works on an airplane, who drives an over the road truck, who is on a railroad, passenger vehicles, transit, nuclear, pipeline. I mean, it's very defined in this box. But outside of that, we have the oil and gas industry that doesn't qualify. We have the mining industry that doesn't qualify. We have manufacturing. We have people working on big fryers and ovens and with customers in a way that safety is a concern. And none of those things fall into that category. In fact, most of the entire construction industry doesn't fall under safety sensitive. Electricians certainly don't if we only go by DOT. All right. So because our state laws are changing around legal marijuana and other drugs, right? Here we are where I think 3 states right now are looking at the legalization of all drugs. So in light of these changing laws, we need to take a look at every person in our workspace and not only ask ourselves, are they doing safety sensitive work? Because we're very often prone to go, well, yes, they are, yes, they are, yes, they are. All right, well, justify that. Tell us what that means. What does that look like? And it's very simple to do in their position description. And the equal opportunity, um, the Employment Equal Opportunity Act says you must be able to show that the employee's inability or impaired ability to perform job related tasks could result in a direct threat. That is part of defining EEOC positions. And then safety sensitive is why each position description should or may not operate under the influence of drugs or alcohol. Okay. And maybe it's you know, they deal with money on a regular basis. Maybe it is you know, they handle you know, equipment. Maybe it's a medical professional. I mean, I left out the whole medical professional industry. Maybe they're dispensing medications, or they have to know how to read, you know, a person's medical chart. So it's not only safety sensitive as far as their own person goes, but how their duties impact everybody else around them, whether customers or coworkers or whatnot. And again, we're just in a place where that's a little piece of the puzzle that's playing into our cultural changes. And I will get a little bit into that as we go along. Now, some things that I need to mention to you right up front before we really dig down into the information. Never, 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 never implement a workplace drug or alcohol testing program without having a policy in place that has been communicated to your employees. That actually is against the law in like 99% of the states. And the reason it is against the law, it actually should be federally against the law, but the federal law doesn't really address this issue except for Department of Transportation testing. Um, but the reason that it should be against the law is because it actually would violate an individual's constitutional right to avoid search and seizure, unannounced search and seizure of personal property. So yes, your urine specimen or your oral fluid or hair specimen would be considered search and seizure of personal property. And if the individual has not consented to the employee's right for that search and seizure in advance, then you should not ever do it, because someone could take you to court in a quick minute and they would certainly win their case. So this is why over and over and over again in court cases for decades now, and we're talking like 40 decades of case history, as long as the employer lets the employee know this is what we intend to do, this is what we will do, this is part of it. Really is kind of saying it's one of those implied social contracts, right? Where if you want this job and you want to perform these duties and get a paycheck for it, you will agree that these are our terms. Once the employee has agreed to that in their employee contract, in their employee manual, in their employee orientation, whatever that looks like, whatever form that takes on, once they've said, yes, I agree to this in order to follow the terms of your employment conditions, then you're fine. You can do pre-employment, random, post-accident, blah, 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 whatever's in your policy. But if you have never done that, then doing the drug test is actually a violation, right? So don't just try to spring drug testing on your workforce unawares or think, well, we're going to change the policy, but first we're just going to drug test everybody and surprise them to see what's really going on, and then we'll change the rules. No, change the rules first, you give notice first. That doesn't mean you have to let them all know we're drug testing you tomorrow. You don't have to do that. You just need to say a drug and alcohol testing program is part of the requirement for you to work here. And then at any point, then you can surprise them with a drug test whenever you want, if it's like in a random fashion or whatnot. I hope that makes sense. If you have any questions on that, let me know. As you're writing your policy, I am going to mention to you regularly that you need to clearly define consequences for actions. In that section, we have a real tendency. I've been helping people write their drug and alcohol policies now for over a dozen years. And what I see is when it gets to the point where we say, okay, what are you going to outline as the consequences for violations? Employers really have a tendency to say, well, we'll handle that on a case by case basis. And there's a couple of reasons for that. They either don't know or don't have the time, don't really want to dig down into what the consequences will look like. They know there will be different scenarios arise. It's hard to think through what those will look like. Who will it be? Will it be the executive secretary or administrative assistant in the office versus a laborer out on the field? Do you handle those differently? Can you handle those differently, et cetera, et cetera, right? So they'll just have a tendency to put that in as this policy phrase catch-all. And the problem is it doesn't work in the long run, because then when situations arise, we just have this innate human nature tendency to treat people differently. And it's not because we're trying to elevate or treat one person in a different fashion than we treat another on purpose. We don't remember the way that it was done the last time. This situation looks, feels, or seems different to us. We just get in this thing of we'll make it up on the fly and handle it as we go along. And the issue with that is that you just cannot help but do it differently. Nobody knows how to cookie cutter every single time. And so you'll be accused of discrimination, and you'll end up in court, and the other party will win and you will lose. Now, am I saying that you have to have one consequence that you follow every single time? No. You can leave yourself room for variations based on the situation. I mean, you can have a company executive who gets hooked on pain medications following a severe car accident, and they never intended to get hooked on that drug, and they need help, and they self-report, and they want to stay with the company and be rehabbed, versus someone who came in and maybe has hit and heroin addiction and is taking advantage and lying, cheating, stealing, robbing the company blind, just not a good, productive employee, puts you and others at risk or in danger, and that person needs to be fired. The other person gets to stay and be rehabbed. Does that mean you're discriminating and you have to handle them both the same? No, and no. However, there are certain points at which that decision tree gets to be made, and differences in outcome get to be had that need to be followed, so that person B, who was the heroin problem, can't say, well, I should get the same treatment as that person did, or else you're discriminating. Okay. So not having any logical chain of command to follow can get you in as much trouble as over stating it. Hope that makes sense. All right. One change that I want you to make in your policy, if you do have a policy in place right now, today at this moment, is anywhere in that policy today where you use the word impairment as a measurement of detection, we are going to delete that and replace it with under the influence. And the reason that we want to do that today is because we do not have an impairment measurement for any drug, particularly cannabis, but there is no impairment measurement for any drug, and attorneys know that. So what is happening is employers are saying, well, we did this drug test, so clearly they were marijuana impaired or heroin impaired or whatever it is, opiates impaired. And attorneys go, what is the proof of the impairment? What is the measurement? What is the standard? Knowing there is none and will not be for many, many decades to come, if ever. And because it can't be proven, the attorney sees on that, and the employers are losing their cases, right? So we want to change it to under the influence, because the presence of the drug in the system can demonstrate this individual was operating under the influence. But impairment has become one of those little glitchy terms that people are seizing on, defining in a certain way and then hinging these huge court cases. So in Colorado, where I am from, today I'm teaching this class from California because I'm visiting my parents to take care of my mom post surgery. But I normally reside in Colorado Springs, Colorado, where we have had legal marijuana for a very long time, since 2012. And so we are having court cases with DUI, driving under the influence, or DUID, driving under the influence of drugs. Some of you have DWAI, driving while impaired. Okay, so however your state defines it, we've had a very difficult time getting convictions because attorneys have seized on this impairment word, and we have people that are 5, 6, 7, 8 times the legal limit that our state established, and they're just walking out of court fully acquitted and not getting convicted of impaired driving because of this little word. So hopefully I've explained that to you enough. Anywhere that you use impairment as a measurement, it needs to be replaced with under the influence. All right. I highly suggest that you use certified collections professionals for your drug testing program. Many companies do this internally, and they'll have like their HR manager or safety manager do their internal drug testing program. Can you do that? Do I recommend doing it? You certainly can. Do I recommend it? It depends on the size of your company. If it's an extremely large company, I think that's a great way to go, and it can certainly be a money saver. However, that individual, no matter the size of your company, should be sent to training and become certified so that they know what they're doing and they do it correctly. It can be quite easy to screw it up. So I can help with certification training if that's something that you need. But if it's not a budgetary concern in and of itself, if you prefer to use a third party, which is good, because then the employee can't say, well, that guy in HR has never liked me and is discriminating against me, or that safety manager, she's always been after me, or she's friends with someone who hates me, therefore they faked my drug test to get me fired. We hear these things all the time in our industry. So for that reason, we often recommend that you will use a third party company or individual or network to conduct your drug screening, but make sure they are trained and certified. There are a variety of programs out there for which they can do it. And if they cannot show you their certificate, you may not have a quality program. Use the correct testing products and the right type of drug test. And I'm not going to dwell on this a lot. I can answer private questions about it if you'd like. But if you want short term, use oral fluid. If you want long term, use a hair test. If you want to find out what's going on right now in a consistent manner, that is the urinalysis. All are highly reliable. Use lab-based drug testing to make an employment decision versus a rapid or point of care test. Those are good tests to do, but they are only a screening test. So you can use a screening tool, and then if something pops up, why then you can send it to the lab for confirmation. But you don't fire someone or not hire them based on a rapid test, because it doesn't rule out secondhand exposure. And then always use a medical review officer who can contact someone about their prescriptions, speak openly with them about that, can review their prescription medications to make sure they're taking them as prescribed, can recommend fit for duty testing if someone may be overprescribed or incorrectly prescribed a medication and is not able to perform their duties safely. So these are some things that can really be helpful, useful tools for you and take you out of the loop of any HIPAA violations. All right, so those are just brief overviews. Let's get into some best practices. Now, I don't know what you all do as far as background. I won't spend a ton of time on Department of Transportation. I've mentioned it briefly. But I do want you to know that the only rule of law in the United States federally concerning drug testing is United States Department of Transportation. But aside from that, federally, employers are just kind of on their own. Now, there are some states that have specific laws, and we will talk about Illinois specifically. So some states have changed some things, but overall they're pretty wide open for interpretation. A few states have some things about whether or not you can do rapid testing and this and that. So we'll talk about that. The one thing that I want to say before I move on is if you have DOT employees, because you're in a safety sensitive field, and then obviously you all also have non-DOT because not everybody is driving the truck or operating the train or whatever the thing is you do. You have to have two different policies so that the non-DOT people are covered and the DOT people are covered. And they need to distinctly address their differences. So if you have any questions on that, let me know. But we do consider the DOT standards the best practice. It is the gold standard. It's sort of like we teach to the test in a sense. We teach to the DOT rules, but we let you know as a non-DOT employer what your options are and what you can tweak and change and make your own. So it has stood up in court, stood the test of time for many, many decades. So it is a very good rule of law to follow. So just a little heads up about that. All right, what's the big deal about a policy in the first place? Why are you here? Why are we talking about it? Why do I have so much to say on this topic? Your policy is your company's rule of practice. And when you go to court on a case where an employee is giving you a hard time, what they're going to say is, what does your policy say and did you follow it? It really is the company Bible. And so it's more than just your drug and alcohol testing policy, it's your employee handbook. I mean, that is your guide. And I like to always kind of take a moment and say this. If you are in this workshop and you don't know where the policies are for your workplace, can't find them, they're in a computer file somewhere, maybe they're in an actual file cabinet somewhere, you had to blow the dust off a little bit, then you are not operating maximally. All right, you are scaring me a little bit if that's the case. If you're HR or the company owner or whatever position it is that brings you here today because you deal with this, that policy needs to be somewhere on your desk or within arm's reach at all times or on your desktop, and you remember where it is so that when an incident happens, you can open that thing up, go to the correct section and follow it and not step outside of the boundary of what that policy says. The reason we want you to do that is because, again, when you go to court, did you follow what you and the employee have previously agreed is going to be the outcome? Okay. So it's clarity of expectations, it's the consequences of the violations, it's the piece of accountability that you have. And again, it's your whole protective factor when it comes to liabilities. Now, if you don't think by anything that I've said already that this is a big deal, I want you to understand that for several decades, 70s, 80s, 90s, early 2000s, um, company after company after company in the United States, when they got sued by an employee for drug use on the job or a positive drug test while at work, and these cases would get appealed up to the state Supreme Court level, the states would rule in favor of the employer over and over and over and over and over again. And so we had a lot of these cases. These kind of cover some different decades. You can look them up on your own time. I don't have time to get into the details of them. But I will mention the very last one was Coates versus Dish Network. That took place in Colorado the year after we had recreational legalization of marijuana. And what happened? The Supreme Court ruled in favor of the employer. And they said the policies were in place. They were clearly outlined. You can prove that the employee knew about them, was aware of them, and had agreed to them. You followed the policy when in the drug testing program. First of all, up with the drug testing program, and then you followed the policy. All of these things are clear. All of them can be proven. Boom, employer, you win. Okay. So that happened over and over and over again. But then what has happened in the last couple of years? All of a sudden, the courts are ruling in favor of the employee. The laws are changing. And so now we have a lot of sympathy to the employee, particularly for medical marijuana use. That's where all the previous cases I showed you and these cases are about medical marijuana. So courts are starting to say, not that the employee just can use medical marijuana. That's not the case. What they're saying is, oh, well, in this case, employer, you didn't define that clearly. You didn't articulate that well enough. You left this portion out. You didn't really say that or state that expectation. You were too broad. You were too general. So the employee really didn't understand, or you weren't compassionate to them, or whatever. So we're seeing these things change, just a little bit of tone and tenor here. And then we have situations where some states are changing their laws altogether for compassionate care, like Oklahoma. Arkansas has the Medical Cannabis Act that I'll mention. Oklahoma is called the Unity Bill. New York City has said job applicants cannot be pre-employment tested unless they're safety sensitive, and the city council gets to define who's safety sensitive and who's not. And I don't know what makes them the experts on this, but my organization has written them many letters to say, you forgot to include this specter of employee and this type of job performance or whatever. So things are changing, and it's a good time to make sure that you pay attention to these details and you're aware of all of the intricacies. Now, make sure that you understand in your policy whether or not you are subject to Safe and Drug-Free Workplace Act mandates. And that's typically if you receive federal grant dollars over a certain amount. And if you are falling into that category of requirement, usually you're aware of it. They will send you some type of notification in your grant packet. It'll usually be a piece of paper or a statement, maybe it's a paragraph that says we will agree to adhere by safe and drug-free workplace policies. And it literally can be a checkbox. So you may have seen that in a grant packet that you have now. Does that mean they're going to come in and check your policies and see if your drug testing program is up to date and all of that? Not likely. However, if there's an incident that occurs, particularly one that costs them their dollars, then you'll come under scrutiny. Then they'll go through it with a fine-tooth comb and see if you followed the policies correctly and had the program in place and followed it exactly, and et cetera. So in the bigger scheme of things, they don't care overall. But then if you drill down into the fine print where an incident occurs, all of a sudden it's a big deal. So I would urge you to do the right thing and follow those policies for your own protection. Again, everything that I'm coming to you with today is about your own protection and liability to protect you as the employer. All right, consider whether or not you have laws in your state about workers' compensation. Some states offer discounts on workers' compensation, payments, and payouts based on whether or not you have a drug-free workplace policy. That's kind of a common thing. So make sure you call your work comp provider and find out if this applies to you. Take a look at your state laws, make sure you're compliant. If you operate in multiple states, in DuPage County, maybe you have employees in Indiana as well as in Illinois. So if you do, you're going to need an Indiana policy versus an Illinois policy. And the policy applies to where the employee is working at the time of the incident. Okay, it doesn't matter where they live, it matters where they're operating. And those two states, though, side by side, are they have very different state laws. So this is something you've got to consider: is multiple states means multiple policies, right? We need to address reasonable cause situations. I'll get into that later, and then any other liability issues like union agreements. Now, one thing that I want to make sure that you all understand: there is a definite underlying culture for people who use drugs where they communicate freely on the internet using pseudonyms about what their employers do and do not allow. And they let their friends know, and they send out the word so that if your company is considered drug friendly, they invite all their friends to come work for you and get hired, whether they know them or not. They invite them on the internet. So This is a huge underground. You can find it online, but a lot of it is moved over into things like Reddit and Twitter and Instagram and the kind of places where I don't spend a lot of my time. But I was teaching this class in Reno, Nevada, and I typed onto the smartboard and just a simple Google page, where can I get a drug-friendly job in Reno? Thousands of sites popped up. I clicked on the first one. Now, in all fairness to Jobs to Careers, they no longer offer this page, but I'm glad I did a screen capture that day. Um, I've done this presentation so many times that I think someone gave them heads up. But so they eliminated this section. However, plenty of other companies do it. So on this day, I got 337 no drug test jobs in Reno, Nevada, and they were listed by categories and some by company name. And an individual in manufacturing was sitting right in front of me, and he said, click on that one. That's my category. I clicked, his company came up second. And the comments in his company said, you have to do a pre-employment test to get your foot in the door. It's easy to cheat, but once you're in, they don't care. They're cool with whatever you want to do. And he goes, well, that's absolutely not true. I'm not cool with whatever they want to do. And I said, do you do random drug testing? And he said, no. And I said, well, then the message that you're sending to these employees is that you're cool with whatever they want to do. You understand? So that's what they tell everybody else. So your implied actions say a lot and don't say a lot. And both of those approaches send tons of communications out to the workforce. So just know that in your policy, if you choose to offer medical marijuana accommodations, you need to be extremely specific about it. You need to be consistent in how you carry out the policy. Don't treat one person differently than you treat another. That's a discrimination lawsuit. Safety sensitive never qualifies. If the individual is safety sensitive, they have to make a choice. You either are a medical marijuana patient and you no longer have that safety sensitive job, or you are safety sensitive and this is off limits to you. So it's one or the other. And then keep detailed documentation of those accommodations, because I promise you, you'll end up repeating it in the future with other employees if you go down that path. All right, let's talk for a brief minute about state law. Illinois does not encourage nor prohibit testing. It's not saying you have to do it. It doesn't say you can't do it. They kind of like to remain ultimately neutral on this topic. You do have the right to a safe and drug-free workplace. It is not illegal for you to require testing. It's not illegal for you to require testing. And it's not illegal for those who have been or in a drug rehab program. You still can do that. There is a discrimination law. We don't know exactly what it means, nor have we for these last 2 years. And typically those that wrote the law or enforce the law say we really won't know what it means until lawsuits happen. So, that's challenging, but we do think, and it is the reason I say to you, don't treat scenarios wildly differently with no reason, because that's kind of how you'll get in trouble. So we suspect that it's that type of thing. Now, what we do know is you cannot discriminate against someone simply because you found out they have a medical marijuana card. Okay, so if you just hear through the grapevine, or sometimes proud employees will just show you, I've got my medical card, there's nothing you can do. Well, you can do something. It's not true that there's nothing you can do. However, you can't just say you're fired, right? You must have just cause. Something has to have happened. You must suspect they're under the influence and document that and go through a whole process. So at this point in time, we know that discrimination means you can't just fire them simply because they obtained the card. All right. So hopefully that's of help to you. A potential employee can be drug tested, providing they've been given a conditional job offer based on the drug testing results. So make sure that that's in your policies, make sure it's in your hiring practices, is that this job offer is conditional based on whether or not you pass a drug test. And you are allowed to do pre-employment drug testing. A lot of people say you can't do it, don't do it, just take it out of your policy. That's not the case. You just have to clearly identify and articulate the circumstances. Any employer that receives funding from the federal government must require testing. So we've already covered that. Employers desiring to receive the funding to promote their drug-free work environment must comply with those rules. We've covered that. And employers receiving funding must set up an awareness program delineating the harmful effects of drugs. So there's something that if you get federal funding, like a grant funding or whatnot for a program, you need to do some drug education. Employers must provide a written policy of their regulations, which of course is why we're here talking about it today, but employees need to have access to it. So your policy is not a secret, it's something that you share with the employees, obviously. And then that must include penalties imposed for failure to pass a drug test. Employees testing positive must be given the opportunity for rehabilitation, counseling, and treatment. So that's something that you need to make sure, and we'll cover that today. Potential employees who fail the drug test will have their job offer withdrawn. Again, that's in that conditional provision. All right, now some people think that the discrimination piece in the law falls under ADA. Others disagree and say that it does not. However, for the sake of the argument, we will say that under ADA, the Americans with Disability Act does not require any employer to accommodate or allow the medical use of marijuana in the workplace. Never, never, never. All right. So you don't have to allow that to take place in the workplace. And that includes if they're working from home during COVID, make sure that everybody is clear. If you are working for company hours or during company hours while you're on the clock, policies apply. Yes, you have the right to do that, but you do need to communicate it and make it clear. It does not require an employer to modify the job or working conditions of a person um, for the use of their medical marijuana if it affects the reasonable operations of the employer. So you don't need to allow it if it impacts your ability to do your job, their ability to do their job. Now, ADA law says you must attempt to make a reasonable accommodation for the medical needs of an employee who engages in the medical use of marijuana if the employee holds a valid registry, as long as that accommodation does not pose a threat of harm or danger to persons or property, or impose an undue hardship on the employer, or prohibit the employee from fulfilling any and all of his job responsibilities. So what that, again, I think it's pretty explanatory, but as long as they're able to perform their duties, it's not going to cost you, it's not going to prohibit workflow, work duties, any of those things. You are able to make accommodations. So this is just an overview of that. I think Jordan will give you a copy of these slides and you can just kind of have this quick and easy outline of that. So some examples of what reasonable accommodations mean according to the EEOC. And again, these don't necessarily qualify under medical marijuana. We're just trying to derive the definition because nobody's given us that information. So we're saying this is how this would apply if someone had another condition. So we're going to layer it over medical marijuana and see if it fits. That's the best we can do since the law is not yet defined. So some examples of what happens if someone, is a quadriplegic or paraplegic and you're going to make an accommodation. You could allow them to work from home. Kind of funny now in COVID because everyone's working from home. You could allow them to work from home if necessary. You could make existing facilities readily accessible for someone with disabilities, job restructuring to part-time or modified work schedules, reassignment to another position, acquisition or modification of equipment or devices, appropriate adjustment or modification of exams, training materials, or policies, and provide qualified readers or interpreters. Now, do any of these things apply to medical marijuana? They may not. We're just trying to help you out and say this is what EEOC looks like. Does it apply? Doesn't it apply? If you need to take those things into consideration, let me know. I'll help you out with them. All right. It is still against the law in the state of Illinois to possess, manufacture, or sell substances or methods that help people cheat on drug tests. So drug test cheating in the industry in Illinois is against the law. I don't know if you know that, but it is illegal to substitute or adulterate your specimen in the state of Illinois. Uh, Not every state has that law. You guys do. It is a class 4 felony. And a minimum fine of $1,000. So you may want to include that in your policy if it's an Illinois policy. All right, so let's get into the earmarks of a good policy. And I'm going to kind of go through this section pretty quickly so we can dig into the meat of the policy for the last half. We'll real quickly check our time. We're doing great. Your policy creates a culture. It really is, it says everything about your company, who you are, how you function, what your core goals and values are. It should start off with your mission statement. It provides clarity. It should be complete, consistent, and it should have a form of communication that an employee can clearly understand. As far as the culture goes, it sets the tone for your company environment. I already mentioned that it's about your values. The clarity, again, I'm going to tell you over and over and over because I want you to get it right. State the violations and the consequences. Don't be vague. Just do your employees and yourself the favor of just being very clear with all of this so that there's no question or loopholes for lawsuits. Okay. It should be complete. Avoid gaps, but do leave yourself opportunities. And you'll see what I mean by that in a little bit here. I'll give you some very specific examples of what this means. Keep it consistent and commit to it. Nothing is worse than spending thousands of dollars. I mean, people will spend $5,000 to $10,000 having a policy written by a high dollar attorney who doesn't know anything about drug testing, so it can be a bad policy. But they'll spend all of this money and then they'll think, well, that's nice to have that on a piece of paper, but we're actually going to do it this way. All right. That's going to get you sued. You're going to lose. So whatever is put on paper, that is what you need to do. So make sure that the way that you want to do it is what is on the piece of paper, right? Follow through every single time so that if you are ever in a court of law, which I hope you're not, but if you are, you win your case. Again, it's about safety, but I'm also with you on liability. Communicate it, communicate it, communicate it. Everyone in the company needs to be aware of it. If you tweak it or change it this week or next week, a memo needs to go out to everybody. Our policies have changed. Here are the changes. You can read them on the website, or here's a hard copy, or hand out a copy, email a copy to everybody, whatever that looks like. Then you get signature pages back they've read and understand. I've read the new policy and I understand it. I read your email and I understand it. Do read receipts on the email. Look, I get this question all the time, so I'm just going to answer it up front. What if they say they read it and they didn't? Now what? You know what? That's not your problem. If they say they read this legally binding document and sign off on it and they actually did not, you're not liable for that. You did your due diligence. If they failed to uphold their end of the bargain, then they're the ones that lose in court, not you. Okay. But again, it's not just a one-time thing. This is not just, well, we changed the policy 5 years ago, we let everybody know, and so they should know what to expect. This is something that you need to repeat on a regular basis, and I'll give you some ideas for that in a little bit. All right, let's get into the policy content. Now, we are about 50 minutes in. This is a good stopping point to take a break if anybody needs a break. Do you all feel like you'd like to take a quick breather and then come back, or do you want me to keep going? Where are we?
I think we can go ahead and keep going, Joe.
Okay, I'm going to take a sip of water.
Sure.
All right, thank you. So your policy is going to answer these questions. And we're going to go through each of these sections. That's what we're going to spend the rest of our time on. What is your purpose or the mission statement for your drug and alcohol policy? How will you make your employees aware of it? And so I've mentioned this to you twice before. We're going to dig down and do a deep dive there. What are the boundaries and expectations? To whom does the policy pertain? When, why, and how will you test for substances? Which substances will be subject to testing? What are the consequences for the violations? And what resources will you provide for those who violate the policy? So let's get into it. All right. The purpose and the mission statement. This may not seem like a big deal, but where this is helpful for you is it's going to justify your whole entire drug testing program. It doesn't have to be, sometimes we hear mission statement and there's a certain personality type, like mine, that goes, oh, that's so boring. Why do we have to do that? And the thought of being in a room with people, if you've ever done it before, to hammer out a mission statement over a day that turns out to be 3 sentences is like the worst thing in the world. No, this isn't that hard. It just explicitly describes your agency's mission that's probably already in place, and how will substance use impact accomplishing that mission? Super easy. So you're going to review the adverse impact substance abuse has or could have on your agency. You can make it long or short. I've seen them that are a few sentences. I've seen them that are an entire page, and I'm like, wow, they're really into this. And so you don't need a whole page, but some people like that. They want to be very thorough. Think about what all goes into this and needs to be covered. You may or may not need to include the fact that this can encompass personnel records, security clearance revocations, employee assistance program records. Maybe it does, maybe it doesn't. Merit System Protection Board actions. I know that Illinois is a heavy union state, whereas the state I live in, Colorado, has very few unions at all whatsoever. So when I write policies for groups or people, they look wildly different compared to the states in which they operate. There can be other relevant items like past or public health, safety, or security risks. So we'll touch lightly on some of these as we go. And then again, large numbers are neither necessary nor essential as far as the amount of detail that you put in here. The preamble simply focuses on the magnitude of risk for even one employee. So I'm going to give you a couple of examples. Here's one where it says our company is committed to protecting the safety, health, and well-being of its employees and all people who come into contact with its workplaces and property and or use its products and services. Recognizing that drug and alcohol abuse pose a direct threat and significant threat, or direct and significant threat to this goal, this company is committed to ensuring a substance-free working environment for all of its employees. You might notice there that I really like using the word substance rather than drugs, because we don't want to forget that alcohol is also a dangerous substance for workplace. So if we say substance, it can kind of encompass any substance they choose to put in their body that causes them to operate in an unsafe manner. Here's an example of one that's a little bit longer, and not tremendously, but you can see that it's just worded a little bit differently. And at the bottom, it says this company has adopted this drug-free workplace to ensure that we're operating safely, effectively. You can put your company mission statement right in there, drop it in, etc. So these are as examples of some options. And the policy examples that you'll be receiving after you take this class will be two different, a short form and a long form. So you can see the differences side by side. Here's where we talk a little bit about how to accomplish employee awareness. So I really love this slide because it just can kind of get your juices flowing a little bit. You are, as I mentioned, that your policy creates a culture. Are you a drug-free culture or are you a drug-friendly culture? And ultimately, you're one or the other. I hate to say that, but that is true. You're either this one or you're that one. And one means you're very intentional about what you do. And the other one means you don't think about it out of sight, out of mind. That's not what you do every day. So you have it in a drawer somewhere in case something comes up. And it tends to promote being a drug-friendly culture, unfortunately. Drug-free means intentional, drug-friendly means out of sight, out of mind. I wish it were not just an either or, but that's where we live right now. So the way to create the drug-free culture is mention that that is your policy every chance you get. So in the new employee interview, you can have right in the application, we do not tolerate substance use for safety because safety is our priority. Applicants who are under the influence of substances should not apply. Simple and easy, right somewhere in the language of the job application. All right. When you're interviewing the employee, you can say that. In the handbook sign-off sheet at employee orientation, At job performance reviews, you can just say, and don't forget, we are a drug-free workplace. Do you have any comment on that? Right? Just so that took me less than a second to say those words. In company-wide meetings, at annual safety meetings or monthly safety meetings, if you are spending hundreds of thousands of dollars on a safety program and never mentioning drug-free workplaces in that space, you are just throwing your money away. So safety meetings should occasionally, at best, talk about a drug-free workspace contributes to safety. Team meetings, and then any other types of reminders where you see as pertinent. All right, who qualifies under your policy or to whom does it apply? All right, is anyone exempt from your policy? Sometimes companies will say management is exempt. Do I think that's a good idea? Of course not. I think it's a horrible idea, but sometimes companies do that. What about contractors? What about vendors, full-time, part-time, seasonal employees? And so anybody that you can think of in the course of what you do, because all of our jobs are so different. If it's a private contractor, maybe you have contract employees and you think, well, how can we enforce our policies with them? They're contractors. You could still have an agreement in the contract that they will agree to operate drug-free as long as they're carrying out your business. But then their ability to do that or enforcement of it is up to them. But you've at least signed off on your side of the liability coin. All right. So that's something that you very much can do. So again, sample verbiage. This policy applies to all applicants, full-time, part-time employees, and all employees of the company when they are on company business or the premises. So this just gives you some good languaging around that. Oops, I went a little further. Um, uh, so including but not limited to properties, facilities, land, platforms, building structures, right? So then you have all these things. Is it a company vehicle? Is it the locker? Is it the desk? What is it in which the company has jurisdiction? It's good to have that language in there. Not always necessary. It just depends on what you do as for your workspace. And then additionally, regardless of your better situation, the employees are always responsible for their actions. So that's something that you definitely want to consider. All right, and then you can include applicants in that. Let's get down to the boundaries and expectations. What is acceptable behavior and what is not? Is it drugs? Are they illicit, prescription, synthetic? Is it alcohol? You may want to define and outline that. Some companies have permissible times where alcohol can be used. Just make sure it's clearly outlined as to when that's okay and when it is not. What are you going to do if you find paraphernalia? Don't forget about that word under the influence, and then always make sure you clearly outline that if behaviors are unsafe, you will address them. Again, this is some languaging around that. And I really like this language, so I'm just going to touch on it really quickly. Being under the influence of drugs as defined in this policy, which is a confirmed drug test and or demonstrating the signs and symptoms of being under the influence. That's a great definition right there. So being under the influence as defined in this policy can also be a blood alcohol content of 0.02 or higher, right? So this is getting into, if it's under that amount, that's none of our business. That's not a legal measurement, but over that amount, we're going to take a second look and there will be some consequences. And so I do like how that wording is. And then of course, bringing any substances into the workplace, possessing, using, manufacturing, distributing, or attempting to in the workplace, abusing drugs, switching, tampering with, or adulterating a specimen. So see, you can get kind of into the details. It's also in this policy, we don't want you disclosing information related to treatment or referrals or drug test results of any other employee. That should all be confidential information. Refusing to cooperate with the terms and conditions. So there's some good things in here that will help you just create that clarity. When it comes to alcohol use, I do very much strongly recommend that you go through this little white box on this slide and answer these questions. This is particularly relevant for the state of Illinois. The last time I taught this policy workshop in your state, I learned that it's kind of been a generational practice for a lot of companies, specifically in the kind of the tri-state region there, to have alcohol Fridays or BYOB Fridays in the office. And many employees that told me about this, or even company owners that told me about this, said, well, it's just for office staff. It's not for people in the field. It's just kind of a casual thing. It's in the afternoon and whatnot. But when I started asking them, does it include hard liquor? Is it beer only? Is there wine involved? Do you have rules about people driving home, or do you have a breathalyzer in the office to make sure they're safe to drive? I got blank stares, like, no, we don't really, no, no, no. That puts you squarely in a position of liability if you're not going to address those issues. So, what are the circumstances where the company is and is not responsible for this alcohol consumption? Will on duty use be permitted? Yes or no? And then, if yes, when, outline it in your policy. Who can or must authorize on duty alcohol use? Will drinking be permitted at company sponsored events? If yes, outline it. Will drinking be permitted at professional functions or meetings? Again, then you outline it. Will drinking be permitted while traveling and or entertaining on behalf of the company? Will the company pay for transportation expenses for an employee who's unable to drive? Are employees permitted to consume alcohol and operate a company vehicle? So these are some little things that you want to address, pay attention to. And again, it's up to the discretion of whoever's enforcing the policy on whether or not you choose these things, but outline it in the policy. Okay, and then we're moving into a section of why will you test? And so let's get into this part, and don't forget to take into consideration any union agreements that you may have. So pre-employment testing, again for Illinois, that's upon conditional offer of employment. All right, and then the drug test outcome can be considered. Random testing must be scientifically selected. I'll get into that a little bit. Post-accident testing, we want you to define what is and is not an accident. Reasonable suspicion or for cause, define the conditions and who determines that. Return to duty testing. This is one that gets really confused by people, and I'm going to give you some clarification. But with a lot of people being furloughed during COVID, many employers are requiring a return to duty test now that people have been furloughed or they've been working from home for a period. They're saying now if you're going to come back and resume these duties in the workplace, you need a return to duty test. Well, that is actually a very wrong definition of return to duty. Return to duty, or RTD, is only used when someone has failed a drug screen and then has gone through evaluation and treatment and is now being allowed to return to work following a clean drug screen. So, in the world of drug testing and medical review officers, and if you have people who must be in the clearinghouse for federal motor carriers, if you were to return to duty test, you're saying they have failed a drug test somewhere along the way, and now they have to have a clean drug test to come back to work, and that goes on their record. So if it's not a failed drug test, don't call it return to duty or return to work. Call it something else. Define it differently. And then follow-up testing is a series of random drug tests determined by a substance abuse professional when someone has failed a drug test, is in treatment, and is allowed to continue to work conditionally based upon the fact that they do random drug testing. All right. So for pre-employment drug testing, define it. You should have a sheet of definitions in your policy. If you're, going to have any type of length or meat to your policy. Employees who are applying, whether it's an applicant, is it for safety sensitive, will be required to submit to a drug or alcohol test. Again, make sure it's conditional. I have the language right here for you that applies for the state of Illinois, so that's very helpful. I don't think we need to spend more time on that. Random drug testing, I want you to clearly understand that we have a problem with people who want to they want to call a reasonable cause test a random. They just are uncomfortable, don't want to confront the employee that they suspect is under the influence. And they would much rather just say, well, we're going to random drugs test that person, than just say we're going to confront them and tell them we're sending you to test for suspicion. It's a thing that people want to avoid conflict. They don't like the conflict. They want to make it a little easier, a little more palpable, but it's actually an incorrect definition and process. So, what I mean by this is random drug testing by federal law in DOT, and therefore is the golden, standard. It must be scientifically generated with another group of people that have also been scientifically generated in a single random draw. So you need a computer generated program, the names go in, the program spits out the name. The odds that, Joe Smith that you suspect of using something or being under the influence will just pop out of that system with everybody else is highly unlikely. So if you try to call it a random and then you're in court and the attorney who knows better says, show me the random list that was generated when Joe Smith's name was drawn with everybody else and you can't do it, you lose your case. All right. What happens is Joe Smith will say you discriminated against me, and he may have a point there because you didn't just say we suspect you're under the influence. All right. So random drug testing must be scientifically drawn and in that way, unannounced. Don't tell people we're doing random draws in 2 weeks. Make sure you get clean. It should be your name was drawn this morning, go directly to the drug test facility to take your test. That's how it should work for it to be the most effective. Can you do it quarterly, annually, monthly? Yes, depending on whatever works for your company. Yes, but just be consistent with it and do it the right way, based on what your policy says. Period. End of subject. That's pretty simple. All right. And then let the employees know what the percentages and the numbers are. You don't have to say we're going to do it quarterly the first week of the quarter. You can say we're going to do it quarterly, and then you should mix it up each quarter so they cannot anticipate when the test will be. But let them know that 50% of everybody in the company will have a drug test each year. So their odds are 50-50. All right. And then their name can come up again. Maybe their name came up in the first quarter and they think, well, I'm clear for the year, so now I can do whatever I want. No, everybody should have an equal opportunity of getting drawn every single quarter. I mean, if someone gets pulled 4 times in a row or 6 or 8, as long as the computer is selecting them, that's not your problem. It should just be computer randomly generated and you're not in control of it. All right, how often will you run your pool? Who will make the frequency determination? Who will run it? Is it a third party? And again, avoid the predictability of timing. Post-accident, make sure you define what is a post-accident and that it's very clear so that people know. DOT has very specific definitions of what is post-accident. So if you have DOT and non-DOT employees, make sure that you differentiate between the two. Very important for you to understand that. But for DOT, there needs to be a fatality or an injury that requires medical attention. What will your company definition be? Is it based on a dollar amount? Some do this and some do not. And also, as far as dollar amount, also look at OSHA rules. You need to pay attention to what OSHA says, because OSHA says if you're in certain types of employee situations or certain types of safety sensitive, if you will, jobs, and someone is hurt in a manner that is clearly not their fault, you can't do a drug test, a post-accident drug test. And what I mean by that is, let's say someone is stung by a bee on the job while working outside and they're allergic to bees and they go into anaphylaxis and you send them to the emergency room and they get treatment and you order a drug test because the damage to you or the cost to you is over the dollar amount. Well, OSHA says, look, that person getting stung by a bee could not have been caused by being under the influence of drugs. It's not their fault. Therefore, the drug test is inappropriate and could be considered discrimination, right? So it needs to be something that the individual could have caused based on being under the influence, if that makes any sense. All right, again, I discussed reasonable suspicion when we were talking about random testing, but I want you to understand that any supervisor working directly with employees should have training on the signs and symptoms of detecting drug use on a regular basis so they're clearly updated with drug trends. They should be aware of what to look for. They should know those employees and what they look like at baseline, so that when they're under the influence of a substance, that supervisor can tell. They know it, they understand it, they can see it, and they can order the drug test. So it's very important to do the right type of test when the situation arises. And again, that's liability protection for the company. All right, let's move on. Who will determine what reasonable suspicion is? Is it one, people, or two? Are you going to have the HR manager come in and verify this? Does a second party need to witness the confrontation? What training are you going to require and how often? And then do you have documentation? If your company needs this training, let me know. That training can come with all of the type of documentation that you need. There are a lot of places that you can find it. Just make sure it's at least a 2-hour training per DOT if you have DOT employees. I already mentioned that return to duty and follow-up testing are when an employee fails a drug test. So make sure that you define those properly and you're not using the wrong type of test and naming it incorrectly. That can get you in trouble. Let's get into the types of tests and what might meet your needs. So a lot of people are under this assumption that if my employee uses marijuana one time 30 days ago and now the random test comes up, now they can fail the test and that's not fair. So we should just stop testing for THC or tetrahydrocannabinol, the impairing substance in marijuana, because our state is now legal. This is all based on misinformation. It's incorrect, it's false. And so let me clear this up for you. Urinalysis testing detects regular drugs of abuse that are used consistently, that are built up in the system. Yes, and recent use is only within a very narrow window of about 36 to 48 hours. Also, if the drug is not yet metabolized in the system, it won't pick the drug up. So for cannabis, you are either